is open court.
This honorable court is now in session. Please be seated.
Thank you. Madam Clerk, are there any preliminary matters for the court to say?
No, sir, Your Honor.
In that case, will you please call the first case?
Skidmore, Camm, Garrett versus Jona, Garrett.
For the appellant, I assume you've already set your time.
I have not already set my time, Your Honor.
Then do you desire any time for rebuttal?
Yes, Your Honor, 4 minutes, please.
4 minutes, okay. You may proceed.
Thank you. May it please the court, I'm Adam Priest of the Knoxville Bar, here with the honor of representing Mr. Camm Garrett in this appeal. As the court knows from the briefing, the issue before the court is the valuation of my client's business, known as Garrett Investment Group to the world, CLG Investment Group as the corporate name. Page 31 of the court's opinion kind of crystallizes this when the court stated that CLG is almost identically similar to Mr. Fuller's business as analyzed in the Fuller decisions. Fuller versus Fuller obviously is another case with a financial planner. We believe that was a conclusion of law where you're applying one case to another. If the court does find that that's a finding of fact, we certainly believe there's ample evidence to the contrary to preponderate against that. It's really all about the viewpoint, Your Honors. You're either looking at this from 30,000 feet, or you're looking at it from the ground. From way up, if you look at the two buildings, it's a one-man financial practice. That's some similarity. Just like if you looked at the dental practice in Lund versus Lund, or the dental practice in Barnes versus Barnes from 30,000 feet, it's two dental practices. But if you went in the door, you would find one dentist over here with small staff. You would find a lot of dentists over here with a lot of staff. This is enterprise goodwill. This is not. This is personal goodwill. So if you look at these two financial planning practices, if you get into the books, you see in the Fuller case, luckily as confirmed by the Hollis case, that's why I cited that to you. This case had the Hollis case just a year and a half ago, where you really reviewed the Fuller case as part of that. So I'm thankful for the Hollis case because Chancellor Bryant had both of those cases, the Fuller case and the Hollis case. So in the opinion that she wrote in the Hollis case that this court affirmed in page 4748 of your Hollis case, it points out that Mr. Fuller made his money selling products. That's what he did. He made $50,000 the year before selling direct commission products and $220,000 the year before selling what we call trail commission products. So now we'll go back up to 30,000 feet. The wife's argument in this case kind of takes terms like trail commission, trail income, fee income, and kind of paints them all with the same kind of fat paintbrush, like this is all the same thing. But if we paint this picture with a much smaller paintbrush and look at the detail, they're not the same thing at all. Trail commission would be you sold a product, and then for the next 4 or 5 years, you just make money without doing anything because you sold the product. Assets under management, which is fee income, which is the same thing Mr. Hollis had in the Hollis case, is you have these customers and you manage their account for them on an ongoing basis, and you negotiate individually with everyone what your fee is going to be for that, not you sold a product for American funds and they're going to pay you whatever they pay you. The client doesn't even necessarily know that even happened. You don't have to disclose that to them. So in these assets under management cases like Mr. Garrett and Mr. Hollis, that's a very specific relationship that's negotiated. So if you look at Fuller, that's a totally different revenue stream than what we have in Garrett.
And so the bulk of your client's income was these advisory fees, correct?
85%, Your Honor.
And would your client be entitled to those whether or not he met with the client?
Theoretically, yes. I mean, he would have a duty to be on top of their accounts, but if they sign the deal.
I mean, yeah, right, I get that. Supposedly he's doing something for that fee. He's not just sitting on the money and letting it grow or
That's correct.
decrease or whatever. But there's no obligation for him to meet individually with a client, to spend a certain amount of time with the client, any service in addition to managing the actual funds.
Would depend on the contract that he had with the client. I mean, if they said we want to meet 4 times a year and that was written in, then he's going to have to do that.
Was there any proof that there were any contracts like that in this case?
No, Your Honor. No individual contracts were entered. So that's true. The big difference being, let's say that customer said, I want to sell this or that. There's no commission at all. If you're in an advisory arrangement, you just either, sell 1,000 different transactions all year for no money other than your advisory fee, or if you're in a commission account like Mr. Fuller, then you get one every time, theoretically, that you sell.
And was the advisory fee always a percentage of assets managed, or did that vary? Did the type of compensation vary?
It might not be the same from my account and yours as an example, but yes, it would always be some percentage of the total assets under management. Yes, Your Honor. So a good analogy on all of that is, if we look at the Fuller case, what was the proof in the Fuller case? Mr. Fuller gave the court a formula to value his trail commissions. I mean, he said it. This is how you value them. And then there was another gentleman that was associated with him that was going to say the same thing. In this case, we have no testimony from Mr. Garrett or a financial planner about any method to value anything. That's a critical distinction between the one case and the other. The other massive distinction being, if you look at the Fuller case, like I said, it says we're valuing trail commissions and it has nothing to do with goodwill, professional or enterprise. Fuller just valued trail commissions. So the weird or the interesting maneuver here on the wife's side is we're going to say the Fuller case applies, but then we're going to give you a totally different methodology on how to value the practice. The term enterprise goodwill does not appear one time in the Fuller case. The term income method as a way to value a business does not appear one time in the Fuller case. But they say the Fuller case applies. Then Mr. Vance, their CPA, says, forget all that. We're going to do enterprise goodwill. And Exhibit 5758 of this trial are his 2 reports, both of which say Mr. Garrett's business does not have one shred of personal goodwill. It's 100% enterprise goodwill. These are terms not even appearing in Fuller. So this is why I say the Hollis case is so important, because in Hollis you have a man who made his money on assets under management also, and Mr. Hollis told this court a way to value his book of business, or that he could monetize it if he retired, and then he had to stay on and work for 5 years after.
I see Hollis against Hollis not so much as showing fidelity to Fuller against Fuller, but rather our court showing deference to a trial judge's factual findings. I mean, isn't that really what it's all about, is we are deferring to the trial judge in these determinations?
Well, I mean, I guess that's one way to look at it, but if there was evidence that preponderated to the contrary, as I'm sure Mrs. Fuller's attorney argued up here, as they had Mr. Vance, the same CPA, then they would have been arguing to the contrary. But if you look closely at the proof, I mean, this is why Chancellor Bryant did what she did. In Fuller, the man gave her a methodology to value the trail commissions, which she did, and you affirmed it. Then in Hollis, no similar formula was applied whatsoever. Mr. Hollis said, hey, I think I can monetize this when I retire under this Alpha program with UBS, or I can go to another broker-dealer and try to monetize this. No formula. But the key here is, in order to do that, Mr. Hollis had to stay on in order to make sure that all these customers stay with the new advisor. So why is that? That's because that's personal goodwill when you have this advisory relationship, which, look at the proof in this case. Not only is there no testimony but from anyone other than their expert about how to monetize this practice or whether it could be monetized. Mr. Garrett says, I don't know how to sell. Critically, not one financial planning practice in McMinn County, Tennessee has ever sold in his 25 years. I say that because he's here. Not one has ever sold. And there's no way, no one's ever approached him to buy it. He has no way to know he could sell it or the trails or anything. But if he did, both CPAs in this case agreed that a non-compete would be required, which everyone agrees under the case law is evidence of personal goodwill in the business. And Mr. Garrett would need to stay on, just like Mr. Hollis, in order to make sure that all these people transition over. So how do we know that to be true? Look at the facts of this case. Mr. Garrett started his practice at Citizens National Bank, worked there for years, and then Citizens sold in Athens, and he didn't like the writing on the wall of the way they wanted him to handle it. So he left, waited out his non-compete with Citizens, and then started Garrett Investment Group. So guess who all the people were that came in the proof in this case? His customers from Citizens National Bank. That was the people that started his business, including quite a few employees of Citizens National who had to be under some pressure to stay at Citizens with the new advisor. I mean, that was their boss. But they didn't stay. They left and came with him. So now today, 97.7%, or at the time of the trial, of his customers and accounts either came with him from Citizens National or were from referrals or other personal relationships that came from Citizens National or his own relationships. So if it's just an enterprise, like Wife's argument would be, you're just a financial planning is just an enterprise, all those people would have stayed at Citizens National. I mean, they wouldn't have cared who their advisor was. They would have just stayed there because it's just an enterprise. But it's not. That shows you the personal relationship between someone, their financial planner, and themselves, that they moved. And that's where these customers came from. So that's why we say any goodwill that exists in this business is personal goodwill and not enterprise goodwill. And the proof just screams that from this case. If you were going to use the Fuller case, let's say this court said, okay, Fuller, kind of looks like this, one-man financial practices, then what you would be doing would be valuing Mr. Garrett's trail commissions, not jumping over to the enterprise goodwill program, which is in no way, shape, or form referenced in this Fuller case. And I put it in my brief for you on that, but if you were actually valuing his trail commissions, it's $127,000 and change would be the formula from the Fuller case. Like if you were using that formula, that would be the value of his trail commissions, the same way that you valued the trail commissions in the Fuller case. But that's why I say, like, you can't paint all this with a fat paintbrush. You have to look at what the Wife's argument is, which is we're going to work so hard to say the Fuller case applies, then we're going to completely abandon all of the logic from the Fuller case and the way that that's done and try to say that there's this, enterprise goodwill. And I think a place that you really see the importance of that is, like I said, Exhibit 57 and 58, that's Mr. Vance's two reports. Like I said, he said that this business had no personal goodwill at all. So if you look at Exhibit 59, that was something Mr. Vance prepared long before this, where he was explaining, how do you know if a business has enterprise goodwill? And the way you know is if it has excellent staff, branded name that's not the owner's name, equipment in place, and ancillary services. All those make money aside from Mr. Garrett. Not one of those things exists in this case, not one. Every penny that's made is made by Mr. Garrett.
Counsel, you said that if the valuation had been just of the trail commissions, you would come up with a value of $127,000?
Yes, Your Honor. If you use the same formula that was used in the Fuller case.
Okay, but your expert applied an asset valuation, correct?
Correct, Your Honor. To answer your question,
$57,000.
both of the experts in this case conveniently agreed that if you use the net asset value, which would be eliminating any goodwill, or another way of answering that would be, say, any goodwill in the business is his personal goodwill, not enterprise goodwill, then everyone agrees in that scenario you would use the net asset value, which they both agree was $57,000. I was just giving you the example that if the Fuller case applied, 127 and change, it's actually in my rebuttal notes there, would be the exact number. But no, we don't believe the Fuller case applies at all for the reasons stated. I just wanted you to know what the numbers were just in case it did. And
Okay,
I know my other
you have your rebuttal.
Sir, thank you.
Yes, sir.
Good afternoon. I'm Randy Sellers. I represent Ms. Jona Garrett, who's the appellee in this case. First of all, a couple of questions that Your Honor asked a moment ago. This was a case in Chancery Court, but it was heard by Judge Mike Sharp by interchange. I know the Hollis case and the Fuller case were both Chancery as well, but that was Chancellor Bryant. Matter of fact, this is some of the findings that Judge Sharp made. I've cited them succinctly on page 6 and 7 of my brief. First of all, Judge Sharp used the term trail income, saying that that was sellable and distinguishable from professional goodwill, which he also used the word reputation goodwill, which is not sellable. So Judge Sharp recognized that concept, and he's citing Fuller when he recognized that. Secondly, he says he recognized and found that it's the same type business in Fuller as it was in the case at Barr. Same 10th Judicial District for whatever it's worth, same decided by the Eastern Section State of Tennessee. He also found that per the expert, my expert or the appellee's expert, Mr. Vance, that trail income can be assigned a value, and this value is thus divisible as a marital asset. That's a specific finding by Judge Sharp. Also, he used Judge Sharp used Mr. Vance's evaluation to assign a value closest to date of trial of $367,000, one half of which he awarded to Mrs. Garrett, payable quarterly over a period of 6 years, which is $2,548 per month.
Remind me where the $360,000 odd dollar figure came from. What does that represent?
That represents the business evaluator of the appellee, Mr. Robert Vance, and it represents obviously he opined that there were 3 methods to use. One is the market approach, which would not apply here because they're correct. There has not been a sale within that area of that type of business. Second is the assets versus liability, which is what their expert used. And then third is the income approach, similar to Fuller.
So is he including in that figure the trail income? Is he distinguishing between trail income versus income from advisory fees and the percentage of this particular individual's business?
You speaking of the judge or the expert?
Both.
Okay. Well, as to the, first of all, the judge found and the expert testified, Mr. Vance, that his number did not include personal or enterprise, professional goodwill, excuse me. And both, interestingly, later on when Judge Sharp questioned both experts on his own, he asked them a basic question. If Mr. Garrett decides to call it quits and go to the beach, says, I'm done, and he's going to get rid of his practice, what is he selling? Well, obviously, he's selling and both experts agreed that he's selling trail income, and both agreed that that trail income would not include personal goodwill. So to answer your question. Now,
But surely there's got to be some recognition that there would be melt of advisory fee income after the principal left. I mean, isn't that common sense that would happen?
there was a contract that Mr. Garrett has with his company.
James.
Yes. And that contract directs what he can or can't do if he's going somewhere else, if he's retiring, if he's quitting, if he's just selling. So, and it does state, and both experts agreed, that he has the ability to sell those. The relationship is what both experts use, and interestingly, no matter what Fuller says, whether it's using the terms trail or personal or professional or enterprise, all those things, both experts agreed in trial that he would be selling the relationships, and that includes all of them. Not all of them are, as counsel stated, there was no proof at all that any of these clients that he had to come in and sit down with him once a year. If they left their business with him, he makes a trail income in 1 to 5 years. So that would be my position on that.
That's what's a little bit confusing to me is sure, it's saleable in the sense that, well, I mean, when you leave a law firm, right, you have to give the client the opportunity, you have to notify them that you're leaving, and then they get to decide, do they want to stay with their existing lawyer or do they want to move to a different law firm? So, under the same sort of situation, we're talking about a relationship with a client, an advisory relationship. Yes, that's potentially an asset, but it's one that you as the seller and you as the buyer don't have total control over because you have a third party in there to that relationship that ultimately has control over it. So I don't know how you value that.
And that may be correct, but all the cases cited by the appellant deal with practices other than this specific one, a stockbroker. And remember, this stockbroker has a contract with its superior as well. That's the difference in that and a law practice or a dental practice or a doctor practice, which were the examples given in the other cases cited.
Yeah, but Raymond James, I mean, if the client leaves, and they say, I want to manage my own investment account, I mean, Raymond James can't do anything about that. They just leave.
That's correct, Your Honor. Yeah. But again, the difference in this kind of business and then a doctor's office or a law office, that type of thing, is there's no guarantee of repeat business in those businesses. In this business, that repeat is there until the person does something about it.
There's a certain amount of inertia that goes
exactly.
with having your account someplace.
Yes. So what we say is that the question is not, was Mr. Vance, the appellee's expert, wrong in his conclusions? Because equally then, that same question should apply to the appellant's expert in conclusions. We say the question is this: did the trial court use the correct standard in being allowed to opine a value based upon a range between the two valuations? And in doing such, did the trial court abuse its discretion in arriving at a valuation? That's the test, not is Mr. Vance wrong. It's whether the court abused its discretion given competent evidence, fact-driven, as was pointed out, I think by Your Honor, in this case, and then can the judge assign something within the range of the two experts? And that's exactly what he did in this case. So we believe that the answer is no. The trial court did not abuse its discretion in establishing a value within the range given as competent evidence. Interestingly, the appellant spent a vast amount of time at trial and on appeal in its brief on the errors or omissions of the appellee's expert, but yet little emphasis again was placed on proving the value of its own expert. Mr. Elkins testified for the appellant. Mr. Elkins used the most simplistic approach to the evaluation of what we say is a complex business. His approach was tables, computers, and chairs minus debt equals value. In the end, however, as Mr. Elkins admitted candidly to the trial court, that there's something else that is sellable besides tables and chairs, and that's the value of the accounts, the relationships, trail income, whatever label you want to put on them is sellable. He was asked, Mr. Elkins, would you advise your client to sell his business to another person for your estimated value of $57,000 under your assets versus liability approach? He stated, absolutely not, absolutely not. And again, both experts agreed on the point that when questioned by the trial court, that trail income not associated with personal goodwill is sellable. We also say the appellant is strikingly obsessed with the notion that Fuller doesn't apply here because of different labeling of concepts used in each case. And if Fuller does apply, this court is required to use specifically the Fuller formula. They say that if you're going to apply Fuller, do it exactly the way they did it in Fuller. That's not what the law is, we don't think. We think the law is there a reliable or reasonable evaluation factually that the trial court can look at and determine whether or not to place a value within a range or at one point or the other. So we say that Fuller is factually analogous to the case at bar, to wit, it's a stockbroker, not a dentist, not a doctor, not a lawyer, and that this court's not bound to use terms peculiar to Fuller only, in other words, to value the business, such as I've already outlined, trail income, relationships, account holders, personal, enterprise, professional goodwill. But again, for the trial court to be allowed to use the evidence at hand to establish a value rightfully within the range of the evidence presented. Now, again, as a side note, and I think it was quite telling, when both experts agreed with each other when Judge Sharp asked them, what's this man selling if he wants to sell something, if he quits? And they both agreed that trail income was something he would be selling. So we believe that the judge had competent evidence from two experts. And by the way, on the experts, before I get into the competent evidence part, I've already stated that neither of them used the market approach. Mr. Vance used both the assets versus liabilities approach and the income approach, but discounted the assets versus liabilities because it doesn't apply to any type of future trail income, which is the asset to be divided. Mr. Elkins only made the one calculation, didn't tell us what it would be if he had made the other calculation. As a matter of fact, when Mr. Vance, the appellee's expert, was asked whether or not personal goodwill was included in his number, he said no, it would be much greater. The number would be over $500,000 if we included personal goodwill. So that was, quote, considered by the court, and the number the judge has would even be higher if it did include the personal goodwill. Does the court have any questions of me as to our position? Thank you.
Thank you, Your Honors. So the fat paintbrush that I'm talking about was in perfect display right there, where we say, okay, if Mr. Garrett retired, we asked these two experts the same questions. If he was to retire and sell his business, would you sell it for $57,000? No. Because he would be selling his personal goodwill to another buyer. Look at the McKeehan case. Yes, it's a dentist case. Something he said I want to touch on. Why did they go to the Fuller case? Well, Mr. Vance was well aware of the Hollis case. He was testified in the Hollis case. Did he reference the Hollis case at any point in time? No. He referenced the Fuller case. And so why did they rely on that? There's not one financial planner, one person financial planner case that either one of us ever found where it was found to be enterprise goodwill. Not one in the history of Tennessee. They're going to make the law here if they say that Mr. Garrett's practice has all this enterprise goodwill in it. But let's go back to the if you sold question. And this is complicated stuff, personal goodwill versus enterprise goodwill. Like there's family law practitioners that I barely understood it for years, and I don't even know if I do now, but I'm trying to understand it. So the point is, if Mr. Garrett sold, then yes, he would want more than $57,000 because he's selling his personal goodwill, his professional goodwill, not his enterprise goodwill. We've already proven that. You asked the great question. Why would these people stay if Mr. Garrett sold his practice? Why would they stay with the new advisor? They don't even know him. The proof in this case is they have to re-sign a contract. A buyer would have to re-sign a contract with every single customer. The revenue doesn't just keep rolling in. That's the fat paintbrush. You have to sign a new contract with every single customer you have. If I was to pass the test, go buy his practice, I have to sign a new contract with all three of you if you're my customers. Your income doesn't keep rolling in. That's completely false. Fat paintbrush. I mean, these are the details. So back to the question about why you sell your practice. I used the McKeehan case. I cited it. You'll see it in the brief. It's a dentist case, yes, because we don't have any financial planner cases. But in the McKeehan case, a dentist bought in for some amount of money, several $100,000, and then Mrs. McKee, Dr. McKee, retired, got divorced later, and the court disallowed that and said that was personal goodwill that was being bought. We're not going to make her pay you out at the same price that this dentist just bought into that practice. So anyway, you get the point on that. The value over the sale would be personal goodwill that the man is selling. Nobody detailed that in the questioning. So of course it's not enterprise goodwill. That's the whole point of what I'm saying. This enterprise has no goodwill. If Mr. Garrett shut down Garrett Investment Group and it said Sellers Investment Group or Priest Investment Group, those people aren't staying. They don't even know us. And the only way they would stay is if Mr. Garrett stayed on for a period of years and made them feel good about it, just like Mr. Hollis had to stay on in his case in order for those people to stay.
Or if the new operation adequately sold them on their services, but that would be a new relationship of goodwill for the buyer.
Of course. That's a whole separate personal goodwill transaction. So to touch on another fat paintbrush issue, so they brought up the issue of whether or not, if my client did try to sell, Mr. Vance testified, if you tried to sell, Raymond James will assist you in monetizing your business. Wrong. Exhibit 55 is the contract. When I asked him where he got that, that was from a website click off the Raymond James website on a piece of marketing material that said, if you try to sell someday, we might help you. The contract, page Exhibit 55, Section 3 says, Raymond James has its sole discretion whether to assist my client in monetizing his account if he tries to sell. So, these are where all these little details come down and really matter, and the only conclusion is that it was an abuse of discretion. I mean, all we have to have is evidence that preponderates to the contrary, that to call all of this enterprise goodwill was an abuse of discretion by the trial court if that was a finding of fact. Thank you, Your Honor.
Thank you. We want to thank both of the attorneys for your presentation. Your case has now been submitted to this court for resolution. You should receive our opinion within a reasonable period of time. Thank you both again.